Hi guys, welcome back to my kitchen. We are about to watch some court. This is a live watch of mine. I haven't seen the results yet, but it is one of my favorite judges, Judge Anna Marie Anzalone. Um, yeah, let's see what she's got. Today is sentencing, morning sentencings from Judge Anzalone. Let's see what we got.
All right, this is in the matter of the people of the state of Michigan versus Christopher Matthew Nowak, file number 2022-20795FH. This is the date and time scheduled for sentencing in this matter. I do have Erie O'Brien law firm. And he is represented today by Robert D. Erie, IHRIE, P26451. Sir, this is the date and time set for sentencing. Mr. Erie, you received a copy of the pre-sentence report, is that correct?
Yes, I have received it, and I have gone over it with my client in detail.
Okay, excellent. So, Mr. Nowak, have you had an opportunity to read and review the pre-sentence report?
What was it again?
Have you had a chance to read and review the pre-sentence report with your attorney?
Yes.
Okay, and you've had an opportunity to discuss it with him as well, correct?
Yes.
Are you satisfied with Mr. Erie as your attorney and the advice that he's given you?
Yes, I am.
All right, Mr. Erie, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
There are a couple of things on it that I would like to correct. In one of the, I can't recall the page, and I can't flip to it on the device I'm on right now, but it indicates that he drinks a pint of Jack Daniels every 2 days. What my client advises me is that when he was in his early 20s and mid 20s, that he did do that, but that's what he told the pre-sentence interviewer, that occurred, years ago, but that does not occur now. Now he drinks beer approximately 1 time a week, and when he does drink it, it's approximately 3 beers.
Okay. All right, so we will make note of that. Anything else?
Nothing else. Am I speaking to the judge? I'm not sure. I can't tell from the picture, the video.
You are. Yeah, I'm the one in the row.
Okay.
You might need to scroll. Okay.
Oh, all here right. We go. Okay. All right. I was on. Good morning, Judge.
Good morning.
Who am I speaking to? He asks. That's hilarious. This is already starting out to be great. We're only 2 minutes in. Let's see what else we've got.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? In this case, I have listed he has 1 prior misdemeanor. Do you find that to be correct?
That's correct, Your Honor. Disorderly person. Yes.
All right. The probation department calculated the minimum sentencing guidelines in this case to be 0 to 11 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. Thank you very much. As the court is aware, my client is presently 32 years old. He, as the court is aware, has that 1 misdemeanor violation from 2 or 3 years ago. We already corrected the alcohol issue with respect to the report. My client is a full-time employed. He has been full-time employed for quite some time. He works for a local restaurant that I am actually personally familiar with called the Cruise Inn. He has been a cook there for 2 years, earns $13 or $14 per hour. I asked him what his plan was for 3 to 5 years down the road in his life. He said he would like to go back to school in programming. He does have training in HVAC work, but has been unable to secure a position in that particular line of work. So the report, when it discusses the pre-sentence report, when it discusses the either the agent's or the victim's version of the events, just a couple of things, Judge. And this comment is not meant to in any way be an excuse or show anything other than an interest in accuracy. The actual time that my client had relations with this young lady, she actually was 16. She had turned 16 in May 15th, and she indicated in her interview with the police officers that the unfortunate event took place in June, so a few weeks after she was 16. But it actually does make a difference in the eyes of the law from a technical viewpoint. But nevertheless, this event that occurred was an unfortunate event. I have permission from my client, Your Honor, to say what I'm about to say. And this too should not be interpreted as an excuse. But my client does have some issues that I think need to be addressed with some type of counseling or even perhaps medical or psychiatric intervention. He is easily manipulable. And in fact, when this event was uncovered, actually was uncovered with my client going to the Warren Police Department and complaining about the fact that this young lady had borrowed his car and never returned. It was, through that rather naive, if you will, police report that this whole issue was uncovered. So I think that the recommendation is a wise recommendation that there be counseling in the event that the probation officer feels that such would be helpful. My client has had a tether, Your Honor, for I think over 2 years at this point with no violation, and that is not only caused some physical problems, but certainly financial problems. And as long as he is, if the court can look back and see that there have been no violations of any kind whatsoever, we would respectfully request two things in this recommendation, which may I say we agree with. We would ask, however, with two excuse me, Judge, two minor changes to it. Number one, that the tether be removed. I don't think that was necessarily a recommendation, but we're asking that it be removed.
That was a bond condition. So
it was. And the other thing, Judge, because of the nature of the offense that he's pleading to, I know that there is a natural desire to eliminate his use of the internet, and that we have really no real objection to. However, we would ask that there be a carved out exception. My client is not all that socially active, and basically he would ask the court to allow him, even though he could not get on the internet, other than to get on like Netflix and other streaming services, to play games on the internet, and to do texting, which is communication with basically the main form of communication these days with young people. And of course, we have no objection to no other internet usage of any kind, but just those three things: the streaming service, games, and texting. And I'm not even sure, quite frankly, I'm going to show my ignorance here. I don't even think texting is the internet. I think it's just a way of communicating. So those things we would ask for, Your Honor. Other than that, my client is ready for sentencing. We do certainly accept the recommendation of the pre-sentence people, and we find that it is compliance with the nature and the conditions of it. I am in a different state than my client is right now, Judge, so I haven't talked to him much this morning, but if the court asks him if he wishes to say something, I will certainly leave that up to him.
Okay, so Mr. Jones, there's an internet agreement that would be signed by Mr. Nowak. Does that allow for texting and streaming devices?
Yeah, Judge, I mean, I didn't restrict the internet or didn't ask to restrict the internet. But we have an internet agreement form that he just has to provide serial numbers for every piece of technology that he has in his residence that would be capable of hooking to the internet. He provides all that, knowing that we can come in and search at any time, put a flash drive in there and search the computer to make sure everything's good.
So there will be no restrictions, Mr. Erie, just that agreement.
Thank you, Judge.
All right, Mr. Nowak, anything you'd like to say on your own behalf?
Just, I'm really sorry just for everything that's happened. I know I made a mistake, and I just been feeling really, really off just knowing what I did. And if I go back in time, I totally would and just eliminate everything that happened. I would use my brain.
Mr. Nowak, you're 32 years old. I know I can tell the difference between a 16 or 15-year-old boy or girl. So I think you need to think real hard about what you were doing, because you're like a year or two shy of being a pedophile. Do you understand that?
Yes.
All right. In determining the appropriate sentence in this case, Mr. Brooks, is it your trial next door? Or you have a trial next door?
I didn't hear anything.
What?
Yeah.
Oh, you're here for Nagy Paul. I have you at 9:30 for Nagy Paul, but your 8 o'clock, I think, is at Judge Olsavers with Miss Iddings.
What 8 o'clock?
I don't know. I don't have you to 9:30, so you're an hour early, but don't you have a trial with Miss Iddings today?
At 1:30, Judge.
Oh, okay.
Yes.
So you're just here to hang out for an hour and a half? An
I
hour?
didn't mean to do that. No. By the way, can't open the door.
Because you don't have access to the back hallway anymore. No attorneys do, but it's okay. I'll talk to you later. I'm going to finish my sentences. All right.
Never knew we became the enemy.
No, you're not the enemy. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's going to be the sentence of the court that you will be placed on probation for a period of 24 months with the Michigan Department of Corrections. You will pay a $750 court cost, $130 crime victim rights fee, $68 in state costs, $60 DNA fee. There'll be a $30 per month supervision fee without a tether. But in the event they need to order one, it will be a $60 per month supervision fee. I am going to defer the 90-day jail term, and that would be deferred in the event that you violate your probation. You would serve that 90 days. You are to have no contact with the victim in this case with the initials AB, directly or indirectly, and you are to have no devices with internet capability without first signing an internet agreement with the Michigan Department of Corrections. I am not going to order that you can't use or possess alcohol, but if it becomes a problem, I can change those terms. Do you understand that?
Yes, I do.
You are to comply with all drug testing, and you are not to use any illegal controlled substances unless prescribed for you by a physician, and you must first notify the probation department of any prescription. I'm going to order a psychiatric evaluation, and that any counseling recommended be complied with. We'll submit to drug testing. You're not to use any object as a weapon. The probation department has the right to enter your residence at any time or your vehicle in search of person, vehicle, or home, and computers. Now, I understand you don't live in our county, so I'm sure you're going to try to transfer your probation, and there's a fee for transferring probation, but Mr. Jones will explain that to you. So,
Okay.
sir, I have your address, and I'm not going to put your full address on the record. So I just want to verify: are you still on Weller?
Yes, I am.
Okay. You're going to receive in an envelope from the court 3 copies of your notice of right to appellate review. 1 copy will be highlighted, and I need you to initial it and date it. And then in that envelope will also be a self-addressed stamped envelope to me. I want you to, initial it, date it, fold it up, put it in the envelope, put it in a mailbox, and send it back to me. Okay?
Okay.
That's your notice of right to appellate review. You're just initially and dating the one to verify that you received it. The other 2 copies are for you. If you or your attorney want to appeal this sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Do you understand?
Yes.
Okay, Mr. Jones, do you have any direction for Mr. Nowak?
He's gonna need to report to our office on Tuesday morning between 8 and 11. So I can get the transfer done. Just to correct something minor, Judge, since he lives within the state, there's no transfer fee. So he would just be, I would just transfer it to his county.
Okay, very good. All right, so Mr. Nowak, you understand you need to come to the courthouse on the 3rd floor to probation between 8 and 11 next Tuesday morning.
Yes.
Check in at the probation officer and at the probation office, and Mr. Jones will meet with you that day. All right, Mr. Erie, anything further?
Nothing, Your Honor.
All right, Mr. Brooks, do you want Latin back? Because we let you through here now. You go through here. My bailiff will allow attorneys back. Okay, all right. So you're all set, Mr. Nowak and Mr. Erie. You can disconnect.
All right. Thank you, Your Honor.
Thank you,
You're
Ron.
welcome.
Wow, that became a lot more serious than I first thought it was. I don't know that I liked the attorney's, I guess you would call them mitigating factors or whatever he decided to say there about a 16-year-old girl, but I did like the judge saying, you're a year or 2 away from being a pedophile, so you need to be on the lookout for that. Yeah. I love Judge Anzalone. She really just cuts down to the chase. A little bit weird to have that other lawyer interrupt in the middle of this quite serious sentencing, but yeah, definitely interesting. And I thought the internet thing was interesting. So basically, they just require that they give them all the serial numbers and access to those devices. But I will say something, and I've heard Judge Manning say this, and we know we love Judge Manning. We stand Judge Manning. If you've been on a tether for a year with no violations, Judge Manning urges public defenders to come and ask for a removal of that. So this guy has been successfully on a tether for 2 years. That's pretty impressive. I mean, it's quite restrictive. So 90 days in jail, suspended, 2 years probation, and no contact with the victim. Not sure we could look for much more than that. I don't know if he got his car back or not. I wonder about that. But anyways, I will check on the rest of this video in another video. But leave your comments down below. What do you think about the sentence and about how Judge Anzalone handled this? All right, talk to you soon.